A settlement deal with RippleXRP was only recently made public by the Department of Justice of the United States of America. It is taking into consideration the particular facts and circumstances that are provided by this case and the corporation. The government has decided to enter into this settlement agreement. There were a number of considerations that were taken into account, including the following: the firm's commitment to maintaining and improving its internal controls, training, and anti-money laundering program, as stated in the attachment. The company's longstanding cooperation with the government and the agreement between the company and the government. This is the agreement that the company has risked to relocate some of its operations, which is detailed in the attachment. That it is the commitment of the company to cooperate with the government in any investigations that are now being conducted at the actions of the company and its officers, directors, employees, agents, and consultants in respect to violations of the Bank Secrecy Act. The government affirms that it will not initiate a criminal or civil lawsuit against the company for any of the actions described in the statement of facts, which is attached to this agreement as attachment A. This statement is incorporated in this agreement in any of the following situations. However, the government may use any information regarding the actions detailed in the statement of facts that is attached against the company in a prosecution for perjury or obstruction of justice, in a prosecution for making a false statement, in a prosecution or other proceeding pertaining to a violent crime. All of these prosecutions and other proceedings, on the other hand, must be completely unrelated to any potentially obstructive conduct that the corporation notified to the government prior to the agreement being signed, and for any activities that the corporation may conduct in the future in accordance with this paragraph. There is no defense that can protect them from being prosecuted. Furthermore, this paragraph does not provide any protection against prosecution for any violations that may have been committed by any current or former officer, director, employee, shareholder, agent, consultant, contractor, or subcontractor of the company, staff, representatives, and advisors on any matter pertaining to bank violations, the act of secrecy with regard to which the corporation is in possession of knowledge or which the government may request information that the company has. Along with the obligation to provide accurate disclosure, the corporation is obligated to provide the government with any document, record, or other tangible evidence that pertains to any violations of the Bank Secrecy Act that the government may question the company about. This obligation is in addition to the responsibility of providing accurate disclosure that was discussed before. This is in response to the governor's request for any information that may be relevant to the investigation into possible violations of the Bank Secrecy Act. The company is required to nominate competent staff members, agents, or attorneys to provide the government with the data and documents indicated in the previous sentence on the business's behalf in connection with the operations of the company or any of its subsidiaries or affiliates, whether they're currently in operation or been in operation in the past. Furthermore, it is understood that the company is obligated to submit information that is true, thorough, and authentic at all times regarding any topic that is relevant to the government's investigation into any violations of the Bank Secrecy Act that involve the company's operations, whether through its parent company or any of its current or former subsidiaries or affiliates. The company is obligated to ensure that the government has access to all of its current directors, officers, employees, of agents and consultants for the purpose of conducting interviews and providing testimony in the United States. This obligation is to the extent that it is feasible given the circumstances. Service investigation includes, but isn't limited to, sworn statements made in federal trials or in front of grand juries. It also includes what happens if, during the term of this agreement, the government decides at its own discretion that the company has broken it by committing any felonies under U.S. federal law after the agreement was signed, or giving false, incomplete, or misleading information about this agreement at any time. Furthermore, it is acknowledged that both the government and the firm have the ability to report this agreement to the general public. Of course, the government and the firm are both bound by this agreement. However, it is made clear that it does not bind any other federal agencies, state, municipal, or foreign law enforcement or regulatory agencies, or any other authorities. The government, on the other hand, will bring the firm's cooperation and compliance with its other obligations under this agreement to the attention of such agencies and authorities if the company makes a request for the government to communicate this information to them. This is in this agreement. Each and every one of the provisions that would be included in the agreement between the government and the corporation are detailed. There will be no revisions, additions, or alterations to this agreement that will be enforceable unless they are made in writing and signed by the attorneys representing the company. XRP, also known as Ripple Labs, is a corporation that has its headquarters in San Francisco, California, and is registered in the state of Delaware. It is a representative that has been lawfully nominated. Ripple Labs, the companies that came before Ripple, made it possible to transfer virtual currencies and provided services for carrying out transactions involving virtual currency exchange, as opposed to a number of other virtual currencies. XRP, which is also known as the Ripple network's currency, was pre-mined and indifferent prior to its distribution. The various currencies, according to market capitalization, XRP is the second highest market capitalization after Bitcoin in the state of South Carolina. Ripple Labs formed a subsidiary that is wholly owned by the company. The SRP Fund 2 was rebranded as the currency ecosystem. According to the guidance, those who are responsible for exchanging virtual currencies and administering them are considered to be money transmitters in compliance with the legislation. The money service business, they are required to register as money service firms. But to provide a more particular definition, the guideline defines an administrator of virtual currency as an individual or organization that is engaged as a business in issuing and bringing into circulation a virtual currency, and who possesses the ability to redeem one in order to withdraw such virtual money from circulation. That a person or company that is engaged in the business of exchanging virtual currency for real currency, funds, and other forms of virtual currencies are referred to as an exchanger. This definition applies to both individuals and organizations. Both exchangers and auditors are considered to be MZBS unless there's an exception. They are required to register with FinCEN in accordance with the Bank Secrecy Act and the guidelines that accompany it. Microfinance institutions are required to fulfill some additional obligations regardless of whether or not they've registered as required. An effective, documented anti-money laundering ML program must be developed, implemented, and maintained by MSBs in order to comply with the Bank Secrecy Act and the laws that set forth its implementation. There's no credible explanation for the transaction after taking into account all of the pertinent information, such as the history of the transaction and the potential aims of the transaction, or involves exploiting the SB to help in illicit behavior. Risk induced to you. As a component of their risk assessment and risk mitigation strategies, MSB is required to develop procedures that involve know your customer and know your customer. As part of these procedures, the MSB is required to comply with the requirements of its anti-money laundering program with relation to foreign agents or foreign counterparties, as well as evaluate the risk that is associated with providing account-based or transactional services to customers based on identification and profile. First one, Zampercy, regarding the anti-money laundered program, FinCEN issued an interpretive release in 2004. The requirements for money service businesses were also included. In his commentary on the new development, John Dedden, a notable attorney who specializes in XRP, mentioned that the Binance settlement will assist in the progression of the cryptocurrency market. And it is interesting to note that Attorney Deaton underlined that the settlement accord reached by Binance would not serve as a conclusion of the exchange. It was assertion that the amount of money that left Binance after Z resigned was far less than the amount that was recorded the previous year when FTX went bankrupt. And according to information provided by Dun Analytics, the cryptocurrency exchange experienced a withdrawal of more than $2.37 billion worth of it after CZ resigned from his position. On the other hand, users deposited a total of $1.78 billion throughout this time period. Of course, at the time of this publication, Binance is holding a staggering $67.47 billion worth of assets belonging to its consumers, which alleviates concerns of a bank run.